Well, it looks like we're continuing to have a few guests join. Chris, what do you think? When should we call this to order?
I say since it's a packed agenda and we've got a bunch here, let's kick her off, Malcolm. Go ahead.
Wonderful. Well, I wanted to start off by thanking everyone for joining us today. It's really great to have a good number of you joining us, and I think we're going to hit quite a few topics that'll be of interest to the community. And I want to, without a great deal of overdue introductions here, I want to make sure that we turn it over to Senator Gordner so he can share a state update with us. But I wanted to give some brief background for those of you that don't already know Senator John Gordner, who was elected originally in a special election back in 2003. He has subsequently been elected to 5 additional terms for representing us in the 27th senatorial district. It includes Columbia, Northumberland, Montour, and Snyder counties, and part of Luzerne County. And he is also, I'm proud to say, the majority whip for the caucus. And with that comes a great deal of allowing Senator Gordner to sit at the table of various discussions that are occurring at the state level. And I think our entire region can certainly be grateful for his leadership and his ability to help craft policy and get things done in Harrisburg. So we're incredibly grateful to have him here with us today. He serves on several committees that are of great importance. He's the vice chairman of the Rules and Executive Nominations Committee, and you might have seen him in the newspaper recently talking about some shifts there, and a member of the Consumer Protection and Professional Licensure Committee, and the Judicial Committee, and the Transportation Committee. And Senator Gordner was absolutely influential in making sure that the Central Susquehanna Valley Thruway received the necessary support and funding from Harrisburg to see that project continue to move forward. Without further ado, I want to turn it over to Senator Gordner and also share that he's been a great volunteer with Scouting. And it's one of the places where I was privileged to attend an Eagle ceremony where his son Cole received his Eagle Award. And it's always a pleasure to have Senator Gordner with us. And Senator, the table's yours.
Okay, thank you, Malcolm. Chris, thank you for setting this up. Glad to share the hour with Kathy Speaker MacNett. We were talking briefly. We've known each other for a long time. And for those of you that don't know Kathy, she literally has decades and decades of experience in and around the Capitol, and very prominent and recognized lawyer. So delighted to have her as speaker as well. And I believe the overtime, the rules, which are very important. I'll just hit on a couple of quick topics and then get to the main focus. CSVT is continuing to move along great. As many people know, there are 3 components to it: the bridge, the northern section, and the southern section. And at this time next year, the bridge in the northern section will be open, and that's amazing. Still get updates every week. The bridge, as many people know, is done, and now they're working on the paving, the concrete parts with the connections on either side, and that continues to happen. But a year from now, that the bridge in the northern section will be open, and will make Joe very happy. The second part is you probably saw the governor's announcement in regard to opening Pennsylvania on Memorial Day, and that is good news. Frankly, a letter is going to him today from, I think it's signed by 25 senators. We're frankly asking him to move it up a couple of days to the Friday of Memorial Day weekend. New York and New Jersey are both opening up before when Pennsylvania is going to open up. And for all those businesses and especially those in the hospitality area, if we could in fact open up on that Friday, which is just a couple of days beforehand, it would allow them to take advantage of the full Memorial Day weekend. So let me just, I have my believe it or not, I still have, no, I guess I don't. I think I'm good. I still have AOL, and I thought that was my AOL account that was making noises, but I don't believe it is. So again, we're going to ask the governor to see if that can be moved up to the Friday of Memorial Day weekend. We're not sure what his response will be. But again, New York and New Jersey are two states that are going to open up before us. Just budget-wise, still challenged in regard to the amount of monies that's coming in to the state and the increased costs. Thanks to the $1.9 trillion stimulus that the federal government passed, Pennsylvania will be getting $7.3 billion over a 2.5-year period. We're going to be using probably around, let's see, a little over $3 billion of it for this coming year budget, which will allow us to get through it without cutting expenses or raising taxes, which is very important. Maintaining the services that people are expecting. So that is good news. And it will allow us to do the same thing for next year as well. We need to continue, though, to get people to work. I am hearing it on a weekly basis from employers throughout my area and around the state that are looking for employees. Our state unemployment level is over 1 point higher than the national average. And there were bad jobs news, if you saw them in the last 24 hours from a national perspective. So I actually, I'm trying to do it on a bipartisan basis. I called Tina Tartaglione, who's the Democratic chair of the Labor and Industry Committee, but I saw in Michigan, they are considering legislation that would provide a $1,000 incentive from those federal monies for people who are currently on unemployment to take a full-time job. And I think it's a good idea to use that. So sometime in the next week, I anticipate again introducing legislation that would incentivize people that have been on the unemployment rolls to take the many jobs that are out there and get $1,000 from the federal monies. Again, we are looking at the incentives, unfortunately, that are going to folks that are on unemployment and getting the $300 extra, which runs through September. So we need to make sure that there are folks that can take the jobs that are readily available in our Susquehanna Valley. Finally, the issue that I've been asked to talk about are the 4 different questions that are on the ballot in a couple of weeks now, week and a half. So there are 4 ballot questions. I am urging folks to vote yes on all 4. One deals with expanding a loan program for municipal fire companies as well as nonprofit EMS. So because it has loan changes, it has to be on the ballot for voter approval. And anytime that we can help out our fire departments or our EMS nonprofit entities, I think it's good. So this would extend the 1% loan program for those entities. So I would urge a yes vote on that. A second amendment, or an amendment that is on there, there are 3 amendments and then this loan question. The one amendment that is on there is to put in our Constitution that you cannot deny rights to people on account of a person's race or ethnicity. So while that is already protected under our federal Constitution, it is not in our state Constitution. And certainly seems like we should be supportive of putting that in our state Constitution as well. So it says that you cannot deny rights on account of a person's race or ethnicity. And so I would urge a yes vote on that. The other 2 questions are the ones that are gaining more focus, and that has to deal with what happens during a state of emergency. Currently, in our law and our Constitution, a governor on his own or her own can declare a state of emergency for 90 days and can continue it for 90 days thereafter. We are now in our fourth consecutive state of emergency dealing with the corona pandemic. But let me just point out, many people will not realize it, but we are in our third year of being in our ninth state of emergency for the heroin and opioid pandemic, or not pandemic, but emergency. So the governor started that 3 years ago, and he has continued it 90 days, 90 days, 90 days, 90 days on that opioid and heroin emergency. So it's just an example of an emergency. We're under 2 right now, but that you can continue it for, we're now in year 3. You know, under what the state Supreme Court has said, the legislature cannot end an emergency unless we adopt a resolution in the House, a resolution in the Senate, and the governor agrees to end the emergency. That ended up going to the state Supreme Court because we thought we might be able to do it just on a resolution basis and not need the governor's approval. But our state Supreme Court said no, any resolution to end an emergency needs the governor's approval. And obviously the governor didn't approve ending the emergency. So the one constitutional question would say that in the future, if there is a resolution to end an emergency, it can be done without the governor's approval. So if there is a majority of the House and a majority of the Senate that says we no longer need to be in an emergency, then that would be the end of it. It would not need the governor's approval, as the state Supreme Court said. It's gray, but when the state Supreme Court ruled, that was the end of it. The second constitutional question will say that a governor can do an emergency, state of emergency, for up to 21 days, and for it to continue after 21 days, that governor would need House and Senate approval to continue that state of emergency. Again, as it exists right now, it is 90 days, and the governor can continue it indefinitely. And here's the argument, and why I supported it, is checks and balances. For the past 13 months, up until one little deviation, the governor has ruled solely. He has made the decisions in regard to when businesses have had to close. He has made the decisions in regard to schools. He has made the decisions in regard to nursing homes. And he has made the decisions in regard to masks, et cetera, et cetera, et cetera. And being a part of leadership a year ago, I would participate in governor's phone calls, but the governor never, as a part of those phone calls, listened and then made a decision afterwards. He made the decision before the phone call, and the purpose of the phone call was to let us know of the decision that he had made or was announcing a few hours later. But in none of those phone calls was it a discussion that would lead to a decision. It was a decision had been made, and he was giving us a courtesy to let us know what the decision was made. So you just look back over the past year. One of the biggest mistakes, frankly, that I think this administration made, and it's been challenging, was his decision early on to require nursing homes to take back folks that were COVID positive. If you go way back to when this whole thing started nationally up in the state of Washington, you'll remember, if you do, that where those first group of deaths occurred were in nursing homes, and what happened in Washington. So we should have learned that lesson here in Pennsylvania and in New York and other states, but the governor mandated nursing home residents that were COVID positive to go back into those nursing home settings rather than to keep them separate. And as a result of that, and we saw it here in Northumberland County, lots of mass problems in nursing homes with multiple people getting infected and dying. If you remember when he decided to shut businesses down a little over a year ago, he made the announcement a Thursday at 5 o'clock and made it effective that evening at midnight. So businesses that weren't determined to be essential, and my dad worked 40 years at Wise Potato Chips in a factory, and he was an HVAC guy. I remember him saying, Wise Potato Chips can't shut down all those lines in 5 hours. They need 24 hours to make sure all the lines and the equipment is shut down in a proper manner. But if you remember, the governor said they're going to be shut down in, 7 hours by midnight that night. And then, for instance, we were the only state in the country that didn't allow real estate to occur at all. No real estate transactions, no real estate showings. We were the only state in the country that didn't allow car dealerships to be open. So we heard from constituents that had cars break down or damaged, and they weren't able to buy even a used car because we were the only state in the country that closed down car dealerships. We were the only state in the country that wasn't allowing outside construction to occur. 49 other states were allowing it. New York, New Jersey, Ohio. We were the only one. So what we are asking is there should be a collaborative process. There should be consultation with the legislature and the governor. So it's not one person consistently over 90 days, 90 days, 90 days, 90 days, making decisions and not being consulted. The governor did it again, if you remember, around Thanksgiving, when after restaurants and bars had already placed their orders for food, the governor gave less than 48 hours notice that he was shutting down businesses for that holiday. If the legislature would have been involved, we would have made sure that if it was deemed necessary, that businesses and hotels and restaurants would have been giving sufficient time so that they didn't already place expensive orders and have them coming and then having to eat those costs or trying to figure out what to do with them. So let me give you the one example. It was interesting. Back in February, as we were getting closer to this May primary date, the governor finally established a vaccine task force. We'd been asking for task force for collaborative groups since last April. And finally in February, if you remember, we were ranked 48th or 49th in the country in regard to getting vaccines out back in February. 48th or 49th. We're almost dead last. West Virginia, if you remember, was second or third in the country in getting vaccines out. We were 48th or 49th. So he established this vaccine task force with a House Democratic member, a House Republican member, a Senate Democratic member, a Senate Republican member, and then 2 of his cabinet positions and himself. So a 7-member task force, but there were bipartisan parts of it. Senator Ryan Ament from Lancaster County has been our member on that task force. And he says it has been outstanding. They have met every week for at least an hour, sometimes an hour and a half. They have free discussions. Every member speaks, and then they come to a consensus when there has to be a decision made. I am very, very proud that we now rank in the top 7 states in the country in the success of our vaccinations and among large states. If you look at us, New York, California, Texas, Florida, we are number 1 in regard to the success of our vaccinations. And it is clear that that is a result of the decision-making and the consultation in regard to that vaccine task force. And so it's interesting, while we cynically think the governor did that to say, okay, we've got this decision coming up in May, I'm going to be collaborative. We think it proves the point that if he would have done that back in April and set up a collaborative process and listened to opposing ideas and then had that group come to a consensus that we can get things done. I mean, I think people are fearful that the legislature is slow or that the legislature would be just opposed to everything, but that's not how it would be. We would work in a collaborative process in order to make sure that the decisions are made. And look, we would have, I mean, if you remember the business shutdowns, if you remember the waiver system, I know Bob Garrett remembers the waiver system in regard to 30,000 waivers, and one business in one county and another business in another county weren't treated equally. The nursing home situation, schools. I remember having a roundtable discussion with my superintendents, and something was supposed to kick in. It was on a Thursday. Something was supposed to kick in on Friday, and literally a half hour before our roundtable, they got new guidance for what was happening in 24 hours from that. And they were all going to have to scramble to try to figure out how that new guidance was going to come into play for them in less than 24 hours. The last point, and I think I saw Martha Milbrand from my office as a part of this call, maybe Mike Stevens from Harrisburg as well. We never received, our offices never received more calls than we did last year. People on unemployment comp trying to get anyone to listen or hear to their unemployment comp claim. They would call and call and call and call and call and not get through to anyone. There was a system set up where they couldn't get through to anyone. So they were thrilled to be able to call my office or Representative Culver's office or Representative Rowe's office and actually speak to someone to get an answer. We could have came up with a system and made sure that they had additional monies to hire folks just to handle the calls. Matter of fact, Elle and I on Monday of next week has hired a couple hundred more people in order for their call center, which is something that they should have done 10 months ago, 11 months ago. But we've got a new secretary there who's very good, Jen, and is doing the right thing. But we think it should be done on a collaborative basis. So I'll just say in conclusion, not sure if there's any questions, but would ask for a yes vote on all of those questions. I think if you go to my website, there's more information. If you click on something, if you want to read the questions. But if you think of all our state of emergencies in the past, normally they're for a weather condition, maybe for a flood, for a snow emergency. They usually last a week or two and they're done. And so we put 21 days in there. Could have been 30 days. It could have been 20. We put 21 in there because if you look at all the past emergencies, 95 or 98% of all past emergencies were done and over in less than 2 weeks. So that would not apply. But if you're going to have a longer emergency, then it should be done in a collaborative process, and it should not be one person making all of the decisions for years. And I'll remind you that we are in year 3 of a state of emergency right now. And if a future governor wants to declare a state emergency for climate change or for some other issue, there's nothing currently under law from stopping a future governor from declaring any sort of state emergency and continuing it 90 days after 90 days after 90 days after 90 days. And we believe that the legislature, the body that's closest to the people, the governor doesn't have to run for election again. We all do, should be a part of the process and at the table. Thanks, Malcolm.
Thank you, Senator Gordner. We really appreciate you taking the time to visit with us today. And again, really appreciate all the work you do on our behalf in Harrisburg, and wish you a happy weekend here. I did want to take one moment as well to acknowledge one of our community members, the Reverend Ken Paul Hammis, who is the administrative pastor at Christ Wesleyan Church in Milton, had initially proposed the topic of going into some state issues today, but also talking about what our next speaker will be covering in more detail, because he was very much concerned about how there could be impacts on our businesses and nonprofits in the Susquehanna Valley. I also have to say that Senator Gordner's staff is an amazing group, and I appreciate Martha joining the call here. She was very helpful as Susquehanna navigated some of those very unemployment concerns that Senator Gordner mentioned earlier today. And of course, I can't go forward without mentioning my good friend Josh Funk, who's a Susquehanna alum, who's chief of staff for Senator Gordner. So the senator's office is well represented with Susquehanna alumni. I wanted to, without further ado, allow our next speaker to move forward, Kathy Speaker MacNett, who the senator already gave a rousing introduction for. We had first met back in 2005 through the Finnegan Foundation program, the Finnegan Fellowship Program. And Kathy has served on that board for a very long time. I'm not sure exactly how many years, and is currently serving as treasurer. But the Finnegan Foundation program is a wonderful opportunity for college students to serve in internships in state government. And I really appreciate Kathy's leadership there. But Kathy's professional work as an attorney is as an attorney and managing member at the law firm of SkarlatosZonarich in Harrisburg. And I'm sorry, Kathy, I'm terrible with that one. But she practices in areas of labor, employment, litigation, arbitration, and investigation. And her primary area of focus is on the management side of labor relations. And that's why we wanted to hear from her today. She's a great expert when it comes to all sorts of business and employment sector related legal issues, helping to navigate FMLA issues, compensation issues, and of course, workers' comp and prevailing wage disputes. So Kathy has a wealth of experience, has spoken on this topic with many other organizations throughout the state, and we're so grateful that she could join us today. And as Senator Gordner mentioned, Kathy is no stranger to all that goes on in Harrisburg, knows a great deal of what's happening both in the city and in the state government. So thank you for joining us today, Kathy.
Thank you very much, Malcolm, and thank you for the plug for the Finnegan Foundation, which originally was set up by Judge Blatt and a number of her friends to honor their friend, James Finnegan, who was then Secretary of the Commonwealth. And it's been going since the 60s. And among the people that we are proud to claim as former Finnegan winners is one of the state senators at this point. So it's paid off well for us over the years. And frankly, it was my entry into the governmental field and also eventually the legal field. So let me go into slides. We do have copies of these available for you if you would like. Let me give the disclaimer up front. I'm giving you generalized information, and I'm giving you generalized information on just a small snippet of wage and hour law. So we're talking about the exemptions because of the state regulation on exemptions, which is going to be more generous to employees than the federal is. And I'll ask Chris to go to the next slide. The starting point for all of this is that the law that is more generous to the employee must be applied. So if that is federal law applies. If it is state law applies. It's almost a reverse type of preemption. Usually if the feds are in an area, they will occupy the area, but here it's the provision that's more favorable to employees. And I'll put in a plug for Senator Baker. Senator Baker has just introduced Senate Bill 523. I think it's the third or fourth session in which he's introduced it to try to iron out some of these differences. But in other areas like this regulation, I think even with a bill like Senator Baker's, that the reg would be considered applicable because it is more specific, but the stricter requirement applies. Chris? The dilemma is that you can be clean under one law and dirty under the other. And let me say up front, I have no respect for any employer who ignores the minimum wage rate. Minimum wage rate is $7.25 under both federal and state at the moment, but there are a lot of employers that don't know that there are provisions in state law that may trump federal law. So if the person is out of compliance due to lack of knowledge, to me, that's a very different situation than being out of compliance because they really wanted to ignore the law, if you will. So don't be clean under one and dirty under the other. Chris? Pennsylvania update, the governor has increased by executive order minimum wage for some classes like state government employees, like state government contractors, like certain employees involved in state leases. That went up to $12 an hour rather than the $7.25 that I just mentioned in July of 2018, and it will go up again in July 1st of 2024 to $15 an hour. There seems to be a lot of talk that $15 an hour may be the right rate at the moment. You may or may not like that as a rate, but clearly that's where a number of these updates are taking us. But this was by executive order. And Chris? The federal federal contractors will go up to $15 an hour on January 30th of 2022. So if you are a federal contractor or a state contractor, you should be aware of these changes that are over the $7.25 rate. And we're ready for the next slide. However, there were regulations, and for a while, some of you will recall that they were talking about increases in the federal threshold. And they went back and forth on that, and it went to court, it seems like a million times, although I'm sure it wasn't. And eventually the feds published a regulation, but what we're finding now is that the state, which was also considering a regulation at the same time, because it doesn't have to be done for exempt employees by statute, it can be done by regulation. The state eventually wound up increasing what they were talking about. And that was passed in June of 2000. It was published in June of 2018, and it became effective last October. The initial increase is in compliance with the federal, so there's no big deal going on. If you're clean under one, you're clean under the other. The problem will come about on October 3rd of this year. And I'm limiting the discussion right now to the exempt employees who are generally referred to as white collar employees. Sometimes they're referred to as EAP. That is not an employee assistance program for this purpose. For this purpose, we're talking about executive, administrative, and professional employees. And we're really limiting it to set the salary threshold for those employees. It's estimated it'll impact about 500,000 Pennsylvania employees, but that was the initial estimate. We'll see what the spin-off effect is when it actually goes into effect in October of this year. Chris? So initially, the threshold was different was increased, so different from what it had been in October of 2020, but it is due to go up again in 2021. And not only in 2021, but there's a third increase in 2022 for these EAP exempt white collar jobs. These thresholds are similar to what the feds had abandoned, but differ in effective date and detail. And we're talking about the white collar exemptions. The failure to meet the salary threshold or to pay the person on a salary basis means that the employer loses the overtime exemption and now has to pay these employees time and a half after 40 hours in a work week. If I were doing this in person, I'd probably be dancing around about right now saying to you, and the week stands alone, and the week stands alone. We're not talking about a pay period. We're talking about each week that the employer has selected. So a lot of employers use the unemployment compensation week, which is Sunday through Saturday. So it's not 80 hours in a work period, it's 40 hours in a work week. And Chris, I'll let you move forward. So the thresholds initially, right now, 684, or what it comes out to about 35, a little over 35.5 annually, exclusive of room, board, lodging. Anyone that's doing that should speak independently to an attorney about what they can claim as the cost that they are using for that. But now it's going to go up slightly over 4,500, okay, $40,560 annually, or $780 a week, as of October of 2021. As of October of 2022, it jumps again, and it's going to be up to $45,500 annually. So we're talking about a higher threshold than the feds have been talking about or have in effect, and that could have significant impact on Pennsylvania businesses. Chris? I will mention there was on that last slide a website. The Department of Labor and Industry, I think, has done a very nice job on trying to update their website, and some individual questions actually can be answered by looking at that website. I will give kudos to Jen on that. Jennifer, has the new Secretary of Labor and Industry, who was the deputy, has been working hard with her people to have some good information, and I'll put in a plug as well for the federal fact sheets on any of these areas, because those are also very good on an individual area. My problem is that often you will find that an employer has a question that is the overlap or the intersection of two fact sheets, and that leaves people kind of scratching their heads because they're not quite sure what is needed. 10% of the salary amount can be made up by non-discretionary bonuses, incentives, or commissions that are paid quarterly or more frequently. And again, there are a lot of things that have to be unpacked, if you will, in that particular bullet. There's a limited catch-up period allowed to make up the difference if you're close but don't quite make it. But again, there are restrictions on those catch-up periods. So you want to be very aware of what you're paying on a weekly basis to these people that fall in the white-collar exemptions. Chris? Okay, still talking the federal white-collar exemptions, and it's anticipated that the federal amount may be increased going forward, but we just aren't there yet. And at some point then it may be that you could be clean under state and dirty under federal. So we just have a reverse situation, if you will, from what we're talking about in October of this year. Chris? I thought it might be easy if you could see a graphic. I find as I'm getting older, I like graphics more and more because it just kind of simplifies things. So we're talking about the executive exemption that is in both federal and state law. We're talking about the administrative exemption that is both in federal and state law. We're talking about the professional exemption, which is in both state and federal law. When you get down to a couple other exemptions that are sometimes considered white-collar-ish, if you will, the computer exemption, you have one in federal law, you have none in state law. So if you are paying compliantly under federal law, you still got a problem for computer professionals. I have a tendency, in spite of the fact that I now have a son-in-law who is a computer professional, to refer to them as the computer geeks, because they're the people that are designing the hardware and software and really know the ins and outs, not just as many of us are users of the box, if you will, but they're actually the people that are doing much of the design. No state computer exemption. There's also a highly paid exemption that started at $100,000 under federal, has gone up to 107,000 and change under federal, but there is no equivalent under state law. And I'm giving you the quick overview. There are all kinds of details as far as whether or not you qualify for these. I find the one that causes a lot of trouble is the professional exemption, because many people have administrative staff or support staff, let me call it, that are very professional in the way they deal with people, but they are not professionals under the definitions in these laws because they do not have the requisite training or background for that sort of thing. So you're dealing more with your doctors and your lawyers and your nurses and maybe some of your environmental people, but you're not dealing with everyone who often thinks that they are a professional. So that causes some concerns. I will also tell you that the administrative exemption is high on the Department of Labor and Industries list and high on the US Department of Labor's list as far as challenging whether or not the person is truly exempt as an administrator. And generally they have to be doing not only managing within your business, but they have to have significant control to spend money without your approval, and money of a sizable amount. So again, your administrative assistant is not going to fall within that administrative exemption, even though there is an administrative exemption. Some of the language in the state reg has updated to look more like the language in the federal, and I think that's good. It's the question of the thresholds that's going to be difficult for some employers to deal with. Next slide, Chris. A higher salary threshold, I think, will be particularly tough on private nonprofit organizations. And that is because of some provisions that are in federal law that are not included in state law. To give you an idea, there are about 1,000 pages of federal law, federal regulation, and federal interpretation. Give me 1 minute to turn that off. Sorry about that. I think it's going to be very difficult for new businesses who don't know the ins and outs of all of this. And I think it's going to be very difficult for what I'm going to characterize as the unwary. Just businesses that thought they were in compliance and had no idea that this was about to hit them in early October of this year. And Chris? Again, there have been increases in the minimum wage rate of $7.25 suggested. We've talked about what the governor did in Pennsylvania previously. He's talked about taking it up to $15 by 2025 in terms of regular businesses, not just government nexus. The federal administration, I have no idea right now what President Biden will be looking for or what Congress will be looking for. Again, I'm expecting that there will be minimum wage rate increases. But again, it's often not the minimum wage rate that trips up employers, it's other parts of the law. And we'll move on, Chris. Some folks feel that the minimum wage should be increased because the last increase in the actual minimum wage rate was back in 2009, which I think any of us would recognize as a long time ago. However, in between, we've had a pandemic and all kinds of other problems associated with that pandemic. I know the restaurant industry or hospitality industry would not be very pleased with an increase in rates generally at this point. There's some belief that an increase in minimum wage rate will assist low-income women. I think we need to wait and see if that pans out. And there's some belief that the minimum wage rate will actually reduce welfare rolls by taking some people off of welfare and putting them into minimum wage again. From what I've been able to see and study, the minimum wage was never designed to be what some people would refer to as a living wage. And if we're talking about living wage, I think we're talking about something different than the minimum wage rate. Traditionally, minimum wage tended to be more your starting wage and not something that was meant for people to raise their families on, if you will. Next slide, Chris. Okay, again, the Pennsylvania law has made it quite clear that it wants to be tougher than the federal for healthcare institutions on overtime, So you have overtime requirements under state law that you don't have under federal law, that are more in terms of how many hours you can work and shift applications that are acceptable or not acceptable. So this is a special law in Pennsylvania, separate and apart from the Pennsylvania Minimum Wage Act. Chris? And I went through that fairly quickly, knowing we had a limited period of time to talk, but I'm more than happy to talk with people about questions that they may have. Again, I have concerns that some of the things that you might believe to be exempt, or things that positions that are exempt under federal law, are not exempt under state law because of the differences in coverage. And I think it's really interesting. Back in the days when I started working with minimum wage laws, it was very interesting to see how these were coming about. And when I first worked with the legislature, there was actually an exemption in the state law that said if you are covered by federal law, you are not covered by state law. So there was no possibility of being clean under one and dirty under the other, because you were outside of the framework of the state minimum wage law if you were covered by the federal minimum wage law. That exemption, or actually it was in the definition of employer and employee, that language was removed some time ago. So now you have these dueling factions, if you will. You have the federal law on one hand, you have the state law on the other hand, and it's not like praying hands that we're talking about. It's more like hands that are going like this, if you will. So some provisions are in the federal, some provisions are in the state, and you better know which ones if you get hit with a wage and hour audit of some ilk. There's some contact information there for you if anyone wants to get in touch with me later, but I'd be more than happy to entertain questions and I'll rely on Chris to tell me how we do that.
Great. Thank you so much, Kathy. Really appreciate your presentation. I'm going to kick us off. I have a question that I received in the chat for you. Then we'll take a few moments. If you're on the call and you have a question for Kathy, I'd like to start with that. And then I do have some additional questions that I'll relay back to the representatives here from Senator Gordner's office. So, Kathy, the first one is this. There's not a ton of chamber members who have in-house HR expertise. So could you give some examples? What would it look like? When should business owners contact qualified HR legal counsel when dealing with HR issues? When would be a good time to contact them?
That's a general one, and we did some teaching through this law firm in something called the Self-Employed Assistance Program for Unemployment Comp with startup businesses, which most of the time were very, very small businesses. One of my partners always said that you should have a stable of people available to you, not only an accountant, but probably a business lawyer, probably an employment and labor lawyer. A lot of firms at this point are choosing to use HR firms. They are good in certain circumstances, but not in everything. I like the idea of building a relationship with a labor and employment attorney so that you can call that attorney and just discuss things fairly easily. My comment to employers is I would rather talk to you about some of these matters on a preventative basis, and that's usually a 15-minute to a half an hour phone call, as opposed to talking to you when you've been hit with some sort of an audit. And we're probably looking more at a significant bill if it is just an audit with one of the administrative agencies, or you're probably talking about a very significant bill if you're dealing with a wage and hour lawsuit. A lot of attorneys have become aware, particularly on the plaintiff's side of the bar, those representing employees, of these discrepancies that we're talking about between state and federal law, and they are taking them to court, and they are taking them to court generally as class actions. You should read class actions as $, $, $, $, $, $, $. And those plaintiffs' attorneys, as I have said to some other folks, are wearing casual shirts that are beautifully made at this point, the male attorneys, because it's clear that they're making significant money on these class actions. I think it's much better to build up a relationship, an ongoing relationship early with a labor and employment attorney so that you can call and just bat some of this stuff around. And I know many of the attorneys will also supply you with information on their websites that you can take a look at. But it's a far-ranging question, Chris, and I thank you for it. But I urge people to find somebody they're comfortable with. I have clients that call me and say, hey, haven't talked to you in a long time. I'm sorry I'm talking to you right now. That translates out as they got a problem right now. And, you know, at least they have the comfort of talking to somebody that they've talked to before. And I pride myself with having some clients. I'm on my third generation at this point with one client. And that feels pretty good because we talk about a lot of far-reaching things, including sometimes some business advice, as well as the labor and employment sort of thing. But as any attorney gets to know your business, it makes it easier to have the follow-up conversations because you're kind of building one conversation on another conversation on another.
Thanks, Kathy, for that. It's interesting. Before we started our call and invited everyone else in, you had said something that is alluded to in this next question, and I'll let you speak to that. Ken Paulhamus, Pastor Ken Paulhamus says this: I believe that these rule changes will have significant impacts on churches, private schools, and other nonprofit organizations, as well as on many small businesses. We will need to reduce our workforce to comply, which will hurt the very people the change is intended to help. What recourse do these organizations have to push back on the rule change, which will impact our staffing and make it difficult to track overtime for salaried staff who will become non-exempt by the change?
Well, I start, Pastor, by saying this is one thing that I'm not happy to agree with you on, but I think you have given a very good summary of what's about to go on. I serve on the board of Harrisburg Catholic Elementary School, and I'm concerned about what will happen because federal law has some exemptions in it. For example, for some positions like teachers that I don't find in the state law at this point. So I think compliance is going to be expensive. I think it will mean for some folks that it will mean that you have to cut staff, and that doesn't make me very happy at all. The regulation at this point has the effect of law. So if it is going to be changed, it's going to have to be changed by an act of the legislature. And I think that's going to be difficult to do. There was a lot of opposition to this change in the regulation when it was going through the Independent Regulatory Review Commission, but it went through that commission, and as a result, it was published and it is now there with the force and effect of law. If you would like to talk at some point individually, I would welcome that phone call because I'm particularly concerned. I know Catholic schools are not the only ones that are hurting right now. A lot of the religious schools are hurting. I know entities that have given good education like the Shiva Academy in Harrisburg, I often hear are having some of the same problems that we are encountering. And I do think all of those are really important, not only as faith-based education, but also in a city like Harrisburg as alternative education for a school district that has its own set of problems. So I think it's going to get more expensive, and I think it's going to be difficult to comply with in some situations. You know, maybe there's a little bit of leftover PPP money if you applied for a PPP that has, especially if it's been forgiven, that would help at least initially. But until the feds are at the same level, I think many of the schools or the nonprofits are going to be in the position of having significant problems meeting these new salary thresholds. And I'm glad that you're on the call for that reason, and hope you'll spread the word to others so they don't get hit in these administrative actions, which people dread But frankly, with the administrative actions with the Department of Labor or the U.S. Department of Labor or State Department of Labor, at least you're not paying the attorney's fees to plaintiff's counsel on top of it. Yeah, it went down hard when it went through, and then it kind of went to sleep for a bit of time. And now I think people are awakening once again to the fact that it's out there. Because I'm hearing not only, I heard from Chris, of course, asking me to do this presentation, but I've also heard from some other groups that are nonprofits that are also fearing this sort of thing. And the compliance is difficult to establish because, like I said, a lot of people consider themselves to be professionals, but they don't necessarily have the education and training that's necessary to qualify them as professionals. I see Alice Ann from the Susquehanna Art Museum is on the call, and they're, in addition to the professionals that I talked about before with the training, there are some exemptions for the creative types that might be helpful in a case with some of your people, but I don't know that you are employing artists per se, but you could probably get those into the creative. If you were, you could probably get some of those folks into the creative side of the professional exemption. But the administrative is tough. The professional tends to be tough. The executive, if you have a very small organization, gets tough because that person has to oversee the work of at least two of their full-time people, 80 hours of work in a work week, in order to even start to meet that exemption as an executive exempt employee.
Kathy, I've got just 3 minutes left for our meeting, so I want to ask you this question, and then I'm going to jump back over to Martha with Senator Gordner's office with the questions we've got for the senator. I have included your presentation in the chat feature. Additionally, I'll be sending out an email with a link to the recording of this meeting so other folks get a chance from our membership to see and to engage with your material. The question I have here was actually from Alice Ann at the Susquehanna Art Museum, and it was, now that more businesses know words like hybrid work schedule and remote working, is there a preferred device for keeping track of hours, and particularly, is there a preferred mechanism or device by labor and industry?
I have heard of no preferred device, but I will mention, as I do in many of my presentations, that no matter what device you're using, you need to document. We are not set up, in my estimation, to really deal with remote workplaces. And we're going to have some trouble with break periods. We're going to have some problems with start and stop times on that. And frankly, the case law is not there to address that right now. So I think in the relatively near future, we're going to start to see some guidance from the U.S. Department of Labor that I anticipate Pennsylvania will follow. But I doubt anything will be as specific as, I'll pick on ADP for the moment, use ADP, to keep your timekeeping, but do keep track of hours. And my advice always has been keep track of hours for your exempt employees as well as your non-exempt. And it may be they generally work 9 to 5, but during this week they worked extra because we had our convention. So they worked and put down the hours so that you have documentation if someone claims that they are not appropriately classified as exempt, because otherwise you're sitting there with your recollection versus their recollection, and that's not a good place to be. Thank you, Chris, for all of your help with this and your help with the slides.
Kathy, thank you so much. I think it's, given how close we came to the end of time here, I think it's clear we're going to want to have you back and talk to you more. Really appreciate your presentation. I'm going to switch over now. Martha, I don't expect you to answer these in 30 seconds, but I will email them to you as well. Some questions we did get for Senator Gordner. First one, what's the prognosis for the passing of an on-time budget? He didn't necessarily give a prognosis, but it seemed like the stimulus funds would certainly be going in that direction, and that should be helpful. So if we could get his prognosis for an on-time budget, that'd be great. next, a little bit more. I think we want to learn a little bit more about the fire companies. First, how many are in our in the senator's district, and how will the loan fund stretch availability of funds for volunteer fire companies? So really, those two questions, I'll email those to you, and then what I can do is pursue answers back to our attendees. So with that, I know Malcolm had to step away. But really grateful for everyone that was able to join us this afternoon, and expect to hear more on these issues. So thank you all very much for joining. We're going to close out our meeting. Have a great day.
Thank you.